Mr. Sikdar, as per the law, the opinion must be rendered by that. It can't be substituted by the High Court. Because when we are exercising the statutory jurisdiction, we can only find fault with the order of the trial court and then remand it back.
My lord, there was the earlier order was two parts, two directions. One was to the tribunal, another was to the Home Department to make verification. Verification report is available with the record. So, my lord, if the verification report supports, police verification report supports my case, it can be decided here, my lord. And tribunal pass order on what basis, my lord? Absolutely, my lord, in contravening the judgment, decision of this honorable court. It is contemptuous, my lord.
No, it can't be.
Yes, my lord. What is the basis of passing order, my lord? On what basis? He has not, the tribunal has not discussed, my lord, the earlier order, if any order, my lord.
There are reasons.
That has not yet discussed, my lord.
No, he has produced a copy of the order. We have to rethink.
My lord, before tribunal, I think there was no copy. And that has not been discussed also. Tribunal, had it been any, my lord, any discussion, there are some other order.
We find that there are reasons, there are compelling reasons. That's why we are rethinking.
My lord, the tribunal has, there was no such order before the tribunal.
There was no
such order. The order
there are another reason.
Case proceeding.
There are another reason. In order to find fault, we must have some introspection as to the issue raised by Mr. Payang. You see, the reason being, we are just making a statement. We'll say when we pass an order, because we'll discuss and then we'll communicate by our order. But from the order produced, we find that there is a good ground, and we can't find fault. We can't say that it is contemptuous. At least, just come back just a moment.
My lord, the tribunal has not discussed other order. CPC transition. Expert order. Hmm? No.
In light of the this judgment in 1093 of 2021, which is in prior and point of time, we are proposing that we take cognizance of this order of 15/7/2021 and provide that this writ petition will be closed. And whenever there is any proceeding initiated against the legal heads of any of the of the petitioner, this proceeding, then this question is kept alive. And in terms of the earlier direction of the High Court, this inquiry has to be done about the difference in the name of voters list, which has been referred to in this page 99. This 97. This order will give you the benefit. If there is any proceeding against any of the legal heads of the proceeding, in terms of paragraph 5 and 6, this benefit can be availed by any proceeding against whom a reference is made. And the allegation that the predecessor interest is a foreigner would be subject to the inquiry which is being made.
Right. And the earlier declaration, my lord, there is judgment by the earlier declaration by the tribunal against him, against my father.
Because the tribunal has closed that, so therefore it is not coming to your against you. You supposing the
Yeah, that's
supposing a
what-
legal representative
My lord,
is being proceeded as a foreigner, that will not be applicable to him because this the High Court direction in your
yes,
favor.
if that protection,
Paragraph 5 and 6 has to be reconsidered.
my lord, that may be, yes, that will help us.
Because there is no quarrel that for every decision of the tribunal, it must be preceded by a notice, separate proceeding to be decided.
Separate proceeding, but since my father, our father has been
No, that
declared,
declaration will not be
foreign
there
as-
because the tribunal has refused to do so. The tribunal after remand has refused to do so. Therefore, it will not be that earlier opinion will not attain finality.
In view of the High Court's order.
In view of the High Court's order,
I got earlier judgment.
yes,
in
because this,
14/6/2023.
yes,
Yes, if that protection.
because that,
prevails, my lord,
you see, by all means, this High Court order at page 94, this is remanded back the matter for a fresh decision and a decision was not taken. Therefore, the proceedings against you, against the proceeding, did not attain finality.
my lord, my lord, that will protect you.
That will protect you.
My lord.
But in one of these cases, Mr. Payan,
Yes.
you'll have to raise a issue
Yes, ma'am.
for bringing to quietus this issue of
Yes, yes.
the
That's why, my lord, I was placing this judgment, my lord, to find it out whether which procedure we will follow, my lord.
because for the present proceeding in this writ petition, we find that this had this ground been taken by the tribunal to not decide the matter, we would have understood that there are conflicting decision before the tribunal. The tribunal did not have any conflicting decision before it, and therefore it just refused. So it is expressly we find it contemptuous. Because the High Court, you see, the principle is that the High Court, once a substitution is done, Order 22 Rule 2 and Order 22 Rule 3 and 4,
Well,
if it is done either in the main proceeding or in a collateral proceeding, the substitution is done.
Substitution is.
So if the tribunal would have proceeded against the substituted what you call proceedings, the present petitioners would have been within the jurisdiction of the tribunal, but the tribunal released them. And it says that there is no proceeding because for by that it means that the proceeding is not there against the substituted heirs. So therefore, Mr. Sikdar must be given a benefit. By substitution, one enters into the shoes of the proceeding that the tribunal did not allow.
Tribunal should, my lord, that's why, my lord, my submission was that if this matter may be remanded, I have no objection. But
No, we are not remanding, we are closing it. Now, if the state wants to proceed against them, you do it in a fresh proceeding and this order will not be a bar. The earlier opinion,
yes,
having been interfered with by remand, will not be binding on them.
Interfere, earlier opinion remain. Upon a report being placed, they will decide, and if it decides, then it will be respected. I think we need to say. Password is- Oh.
Okay. The password is in chambers.
well,
You'll be given that protection.
well,
Because you
Keep
don't
it.
have to say so much.
well,
The paragraph 5 and 6 will operate in your favor.
We are not giving you a protection. Protection is given by the law itself. That
My lord.
proceeding, there must be a
Yes.
notice.
Take copy of that.
Lordship. Item
Yeah.
27. Oblige, your Lordship.
Court will take a note of it. You just ask some of your colleague to make a mention.
Lordship. Oblige, your Lordship.
And item 1 fixed at 2 p.m.
the rules stamped, my lord, one copy of the rules. It is amendment of 2009 rules.
Internet is restored. Internet restored.
Which,
My lord,
which particular route?
yes, 10A that has been inserted in the, my lord, 2009 rules.
What is the effect of that?
My lord, under this, for this, my lord, your lordship may have to see, kindly see the Citizenship Act, my lord. Citizenship Act, my lord.
Yes.
Citizenship Act, my lord, in the interpretation clause, my lord, section 2. Section 2, after clause 2, my lord, the term illegal migrant has been defined and it is provided for
Yes.
this provision only. Illegal migrant. And this provision, my lord, has provided that any person belonging to Hindu, Sikh, that concept, my lord, Jain, Parsis of Christian community from Afghanistan, Bangladesh, who entered India on or before 31st day of December 2014 and has been exempted from central government by under the clause so and so Passport Entry Act or from the application of the provision of the Foreigners Act 1946 or any rule or made thereunder shall be treated as illegal migrant, shall not be treated as illegal migrant for the purpose. My lord, the section 6 thereafter, look, my lord. Section 6 may be seen. This is citizenship by my lord, neutralization. However, those who are illegal migrant, they are debarred from application under 6, my lord. Now under 6B, my lord. So that term illegal migrant has been defined that those who are coming up to 31st of 2014 from these communities, they will not be treated as illegal migrant. So now they can apply under 6B, my lord. 6B of this act. Citizenship Act.
So these amendments are brought in the rules.
No, this is in the act first, my lord. This is in the act. Now it is in the rule, my lord. 2024, in the 2009 rule, this amendment is brought.
Now, which rules are these? Citizenship rules.
Yes, citizenship rule 2009, my lord. That book it is contained, 2009 rule is available in the book, my lord.
Yes.
Only in that, my lord, in that book, this after 10, my lord, this 10A will be added, my lord.
Yes.
To facilitate the registration, my lord. Then directly 10A1, my lord, 10 1B, my lord, 10 1 to 10 2, my lord. There is a process. The application form is there, my lord. It must contain some documents. Now, my lord, how to apply the details given in 10A, my lord. 10A1. 10.2 says every application made applicant under this cell.
1 minute, just one. What it- That is instant. You can examine that. Sorry, carry on.
Yes. My lord, as your lordship has said, 10A1, it contains how to apply details. The details is given. Then 10.2, my lord, 10A2. What should contain in the application, my lord? There shall be a declaration to the effect that the citizenship of his country shall stand renounced irrevocably in the event of his application being approved, and he shall be raised. He shall not raise any claim or in future. So it is not granted, my lord, directly citizenship is not granted, but they have to make an application. It is the central government who will scrutinize. After scrutiny, my lord, if necessary, they will grant it. And for that, what application? Section, my lord, 3. 10A3, my lord, it contains what should be the documents to be submitted before the registering authority. A copy of any of the documents specified in Schedule A. Schedule A is given in the rule, my lord. And a copy of any of the documents specified in Schedule 1B. Schedule 1B also there in the rule, my lord. And affidavit in the form of specified Schedule 1C. These are the only materials, my lord, which is to be submitted along with the document application. Now thereafter, the authority whose application may be met, the whom application is to be met, it is also given. Who will make the scrutiny, that is in my lord 13A, 11A, my lord, to whom application is to be met, it is given specifically. 13A, who will scrutinize the application, make the scrutiny of the application, my lord. And the form is there in the application form is there, my lord. Thirteen A says, my lord, 13A, which is inserted now. It has said The Empowerment Committee referred in 11A may scrutinize the application for grant of citizenship by registration or neutralization submitted by an applicant under section 6B to ensure that the application is complete in all respects, and the applicant satisfy all the conditions laid down in section 6B. Then on being satisfied, after making such inquiry as it considers necessary for it.
Mr. Pang, yes.
Page number
50. The question is really excellent. Yeah. Okay, second. We leave that to the wisdom of Mr. Hussain,
Yes,
the manner of applying,
yes.
but
We may not say anything on that, my lord. If they apply, they may apply.
Mr. Hussain, we may record this as a submission made by you. Because we, from the documents referred to in this amended schedule of the rules, the documents by the FRRO is acceptable. I don't think you will suffer any prejudice.
Indeed.
Heard. Mr. I. Hussain, learned counsel for the petitioner. Also heard. Mr. J. Pang, learned standing counsel for the Home Department representing respondent numbers
2,
2, 5, and 6.
I will be my. Yes,
Five you will be there.
2 and 6, man.
2 and 6. Mr. S.K. Zarika, learned government advocate appearing for respondent number 5. The respondent numbers 1, 3, and 4 are unrepresented. Next paragraph. By filing this writ petition under Article 226 of the Constitution of India, the petitioner has assailed the opinion dated 37/2018, page 4. By so and so. Declaring the petitioner to be a foreigner who has entered Assam on or after 25/3/1971 and further opining that he is liable to be deported to his original territory, until then to be kept in the detention center as an internee, INTER, within the provisions of law. Next. The learned counsel for the petitioner has referred to the written statement filed by the petitioner before the foreigners tribunal, as well as we have filed a written statement and additional written statement. Written statement. We have filed additional written statement also.
I've not annexed a additional written statement, your lordship.
I'll present it.
No, your lordship.
No,
No, your.
written statement. And petitioner had examined himself as DW1, who is this Subha Das?
So what else is the principal, your lordship, of that?
What is the principal? His projected sister, Sobhagya, Subhagya, Bhatto, Bhatta, as DW2, and also examined was Subha, Subha Das. Comma. Where is her evidence? Subha Das,
What else, your lordship, I have annexed it, your lordship. It starts from page 25, your lordship.
25. One- comma, the head teacher of Surendra Das Prathamik Vidyalaya, SURENDRADAS Vidyalaya, VIDYALAY, SDW3. And the exhibited documents Where is your documents? You have not referred your documents in the exhibits
Lordship,
in your evidence?
Your Lordship, Your Lordship,
Where do you find the reference to the exhibited documents?
Your Lordship, in the order itself, Your Lordship. Page
Only from
40,
the order.
page 44.
Okay,
Lordship.
and the following exhibited documents, page, on page 44.
The deposition only registration is referred to. In the deposition of the only, okay. Only the registration migration is referred to. Page 32. Migration certificate. Migration and citizenship.
It may be mentioned that in the deposition of the petitioner as DW1, I mean, he is only referred to migration certificate as exhibit of the,
4 exhibits are referred to. Exhibit Ko, Ko,
Acha, हाँ.
Ko.
So that is exhibit co. Exhibit co is citizenship registration certificate within bracket exhibit co. Copy of Jamabandi within bracket exhibit go. Voter's identity card within bracket exhibit go. And certificate issued by the Gambura within bracket exhibit go. Who has exhibited the other documents?
Sorry, Lordship.
Okay, the first one. DW2 had introduced, had exhibited
Full certificate.
a school certificate as exhibit cho. Another school certificate as exhibit cho, CHAA. Accordingly, it is submitted that the evidence has not been considered by the learned tribunal in its proper perspective and arrived at a long and incorrect conclusion. By holding that the petitioner had failed to discharge his burden under section 9 of the Foreigners Act of 1946 to prove that he is not a foreigner but a citizen of India. This is, there is no discussion why this was decided. When he applied, it not be the parties will examine this in this power because it is not been explained by the other. So the per contract of the Learned Study Council for the Home Department has made its submissions in support of the impugned opinion and is submitted that the petitioner has failed to prove his linkage with his projected parent of Indian origin. Of Indian parent who is allegedly who has allegedly migrated from the specified territory into India. Specific territory, i.e., the then East Pakistan into India. Next paragraph. On an examination of the materials available on record, it is observed that the learned tribunal had rejected the copy of Jamavandi within bracket exhibit 3 and 8, which are of the year 2004 and 2014, on the ground that they do not assess the petitioner to prove his linkage with his Indian parent. Although the petitioner had relied on Gambura certificate within bracket exhibit 5, the same was discarded on the ground that the concerned Gambura, who was the author of the said document, had not come to depose in favor of the petitioner. Similarly, not similarly, the learned tribunal had discarded the school certificate within bracket exhibit 7 of DW2, who is the projected elder sister of the petitioner, on the ground that the author of the said document had not come before the tribunal to depose in favor of the to prove the contents of the said document. And accordingly, exhibit 5 and 7 were held to be inadmissible in evidence. First of all, the learned tribunal had discarded the voter ID within bracket exhibit 4 of the petitioner issued on 1/10/2013, as well as the voter ID card of DW2 within bracket exhibit 9, on the ground that the enlistment of the names, their names in the electoral rolls do not prove the citizenship of the petitioner and does not link him with the Indian parent. Which page is that school certificate?
Page 24,
22.
24, 23, 24. 23 is the translated copy, 24 is the one copy.
First off, it may be, it may be mentioned and clarified herein that although in the records of the tribunal,
Because of 1, 2, 3 for election.
again, in the evidence recorded of the DW 1, 2, and 3, they had referred to the exhibits as exhibit Q to CHAA. But the said documents are referred to in the written statement as exhibit 1 to 9. And accordingly, in the opinion, the learned foreigners tribunal has also referred to the said exhibited documents as exhibit 1 to 9. First off, in respect of exhibit, this DW3 school certificate is which one? 7, 6 or 7?
It should be 7, Your Lordship.
7.
Yes.
First one, in respect of exhibit CHA, which is recorded as exhibit 7.
Yes.
It is seen from the deposition, from the cross-examination of DW3 that she has denied that the said certificate contained her signature and had stated that the signature is in the name of Shobha Rani Das. And therefore,
Lordship, may I interrupt? Exhibit 6 is the certificate related to the petitioner. And exhibit 7,
Six.
6. Exhibit 7 is
Okay.
the school certificate related to the DW2. So
okay, then
DW3
make it 6. And accordingly, while denying the signature, she has stated that she does not know who has issued the certificate in her name. Full stop. She had further stated that she is working in the said school since 2011 and the said certificate is of the year 1990, whereas the said school was not even established at that time. Full stop. In order to counter the said statement in the cross-examination of DW3, the learned counsel for the petitioner has referred to certificate annexed as annexure. Which annexure?
Annexure 3.
Huh?
Annexure 3.
Annexure 2,
Annexure 3,
3 page
page 24.
to annexure 3 to the rate petition project that the author of the said certificate was one Shobha Rani Das, whereas they had examined, whereas the petitioner had examined Shobha Das. And it is sought to be projected that that there are two persons working in the said school with similar names. Full stop. In this regard, the court is of the considered opinion that as the said certificate has not been introduced in evidence before the learned tribunal, the court would be slow to take cognizance of a document which is produced for the first time in this writ petition. So as to disturb the for the purpose of examining the correctness of the opinion impugned in this writ petition. Full stop. In next para, in the present case in hand, it is the petitioner who had called the DW3 to prove exhibit Chaw within bracket exhibit 6. And despite her statement in the cross examination, the petitioner had not re-examined DW3. Full stop. Therefore, from the materials available on record, the court finds that notwithstanding that the petitioner has produced the document of the projected father of the petitioner to have migrated into the country by way of for which he places reliance on migration certificate dated 29/5/1956. Which also bears a date of 28/6/1956 against in respect of migration certificate number 83/27/5/7272 dated 14/5/1956, as well as the certificate of registration. Sorry, make it copy of registration certificate bearing number 80103 issued at Tejpur, issued by the registering authority at Tejpur in the name of Kitish, KHITESH. Next word is Chandra, CH. Next word, DEB. The project, the person whose name is entered therein as his father. But as the only document to connect the petitioner with his projected father is the school certificate within bracket annexure Chaw public annexure 6, not exhibit 6, exhibit Chaw. The court is of the constitutional opinion that the impugned opinion dated 30/7/2018 does not suffer from any perversity whatsoever. Next paragraph. At this stage, the learned counsel for the petitioner has referred to the amendment made to the Citizenship Act, 1995, by way of citizenship within bracket amendment, bracket close Act, 2019, as well as the amendment to the citizenship rules, 2009, by way of citizenship within bracket amendment, bracket closed rules, 2024. It is submitted that the petitioner, being a Hindu, is entitled to make an application for grant of citizenship by registration or naturalization. And in this regard, it is submitted that the only document to connect the petitioner is that one of the documents on which the petitioner intends to rely for the purpose of his registration, for his citizenship by registration or naturalization, is the migration certificate and the certificate of registration referred above. First of all, it is submitted that in the impugned opinion, the said two documents being Exhibit 1 and 2 were discarded as the tribunal had doubted its genuineness. Now it is submitted that when the application of the petitioner is being processed, application of the petitioner for citizenship is being processed, the authorities would may not be prejudiced with the opinion impugned in this writ petition. Next one. The said submission has been considered in light of the amendment carried out to the Citizenship Act and the citizenship rules. To stop. Notwithstanding that the court is disinclined to interfere with the impugned opinion dated 30/7/2018, passed by the learned Foreigners Tribunal number 8, Tejpur in FT within bracket 8, bracket close, case number 1340 of 2017. Arising out of REF, full stop, capital Tejpur TZP within bracket capital B, bracket close, memo number 5672/2004. On the ground that we are inclined to accept the prayer made by the learned counsel for the petitioner in respect of the migration certificate and certificate of registration, which was exhibited as exhibit co and co within bracket exhibit 1 and 2. As the learned Foreigners Tribunal had merely doubted its genuineness, but did not declare he said documents to be fraudulent or forged. So accordingly, it is provided that in the event the petitioner applies for citizenship by way of registration, or naturalization, it would be open to the concerned authorities to examine the genuineness of the said certificates without being influenced by the opinion dated 37/2018, passed by the Learned Province Tribunal, 8 so read the full thing, huh? Seven, accept the observations made hearing before with regard to the right of the petitioner to apply for registration or naturalization from the official stance dismissal. There may be some corrections in the order. Uh, Correspondent, your name? I forgot again. AI Ali.
Is appearing on.
Oh, sir.
Yeah.
Your name? H. Uli on behalf of AI Ali. Correspondent number? 3. Okay.
Item 7. Item 7 for motion.
May I please your lordship file here in this case? The the petitioner was decided foreigner by an expert.
Yes. Just. Yes, you have any?
Yes.
material?
Report.
मेरे घर पर मोबाइल नहीं ये रह क्या होगा
Do you know নাম চেঞ্জ কৰি নাম চেঞ্জ কৰি আছে তাই
Mr. Sikdar,
माइल
they are now disclosing that the Shab Khatun had changed her name and with the changed name she appeared as Sahimon Nessa. And this Sahimon Nessa and this Sharp Khatun are same person.
My lord. Uh, my question is, my lord, I don't know who has
No, she,
Say-
the SI has met Sahimon Nessa.
Asa has met my lord,
And she has
Saibul Nasa and
produced-
Sapkatan is same person.
And they have gone to the extent of saying that when they asked about the nationality documents, she has produced the voters list of 1997 recorded as Sharp Khatun.
Will proceed produce.
Not this proceeding, this Sahimon Nessa. The
Well.
police inquired.
My lord, the voter list are all of, my lord, sometimes prepared, my lord, without giving personal hearing.
No,
And therefore, there may be an anomalies in the name.
No, I
lord,
understand, but now here
question
is
is, my
a
lord-
case, here now here is a case, the state is trying to project that this Sahimon Nessa and Sharp Khatun are same person. They are not different identities, but they are same person. And they are making a specific allegation that the statement made is that the voters list of house number 78, serial number so and so, of 1997, she is shown as the voter. And in the same voters list,
Hmm.
the name of her husband and others are also recorded. And after 2005, her name is recorded as Sahimon Nessa of the same village, wife of Julhas. So this is assuming a new identity,
My
but she's the same
My
person.
lord, my name may be changed, my lord. And for that, who is the responsible for changing the name, my lord? Kindly see, my lord, the 89 voter list. There, my name has been recorded as Mahimon Khatun. That is that I have annexed in.
No, that's
annexed
okay.
11.
But you see, now the allegation is because you were trying to project that these two people are different. But now the
No.
investigation reveals that they are same person. So if that be so, you take instructions because otherwise you will find no ground to proceed with this. You will have to file an affidavit, but
My lord,
Mr. Payang, you have to file an affidavit to say this.
my lord, my challenge is against the whole proceeding. My lord, the LBO report is also annexed here, my lord.
No, but
The
that
LBO
was-
report is totally blank. How they have carried out
No, that is
verification,
that is another part.
my lord, that
Mr.
part,
Jigar, that is one part.
my lord.
But the first part is, in order to proceed with this matter, we'll have to proceed with the presumption that these two persons are same. Then only we can entertain your challenge to the opinion or rendered on the opinion rendered, because otherwise, if you claim that you are a different person,
No, my lord, we are not
He's also
saying
not
so,
claiming
my
now.
lord. We are not saying
Now
so.
he is also accepting this.
My lord, we are not saying so. The
okay.
voter list may wrongly recorded differently, but that Sapkatun in the 97 voter list is of,
Last time,
my lord, same village, my lord.
no, you submitted last time that you are two different person, name of the husband is similar.
My lord,
Therefore, the police is, you are being harassed by the police. That is why we made a pointed query,
my lord,
find out.
my problem is that, my lord, these proceedings are drawn up without preliminary investigation, without collecting materials of doubt.
This proceeding, the order passed in ex parte, where is that order, page number
My lord, that is 17.
17.
Yes.
Kindly see the name of the proceeding.
Yes, here name is Sapkatun. Sapkatun.
You are not sub Khatun.
Correct.
So far as this writ petition is concerned.
You are
So
either-
you have to explain why Sahimon Nessa is putting a challenge to an order passed by the FT against sub Khatun.
No, he has made a simple petition before the tribunal that my name is not Sabkatun, I am Simon Nessa. And that on the basis of that, the tribunal has issued a fresh notice to Sabkatun. And the Gavura, there is a report of Gavura that Sabkatun is not residing in the village.
There is a report which has been submitted to the inspector now,
My lord.
where it says both are one and the same person.
My lord, that could have been done at the very beginning. That should be done, or to have been done at the
What should have been
preliminary
done is a
stage.
different matter. What is it? But now we are,
That you don't know your name.
My lord, that report, that would have been a report if they have
no, that is
made a
something
reference by
which-
investigation.
No, no, Mr. Sikdar, that would accept only when there is no identity crisis. If Sabkatan, if you admit that Sabkatan and Simon Nessa are same, then we continue to, we record your statement and we record, then we continue to hear you. Because once you see, here is a case where the reference to Sabkatan is being challenged by Simon Nessa. We have documents now, opinion of the SI to say that the two are same people. So if there's a change in identity, you see, you take a
My lord.
risk. You take a risk about the fact
My
that
lord,
once there is a change of identity,
My lord, we accepting that position, my lord. My challenge to the whole
and then
proceeding,
we'll record it and then we'll take it up.
my lord. My
Then
lord,
we'll take it up.
I may be, my lord, same person, my lord.
No, but
Then you go and appear before.
My lord, but my challenge to the whole proceeding shall remain alive, my lord. Because this report, if the preliminary investigation was there, the proceeding would have not been against any person.
You can bring it on record, Mr. File.
yes,
As early as possible.
and you also file an affidavit that these people are same.
My lord,
And then
I will accept that. my lord.
then we'll
My
do the needful, we'll
Yes,
pass
sir.
appropriate orders. Then
My
we can
lord.
remand it back to the tribunal on the legal ground available.
My lord,
can do
recording
it.
everything, my lord, and keeping my my point that maintainability of the proceeding, ground of maintainability of proceeding shall remain alive, my lord. Keeping that, my lord, lordship may close it at this.
No,
stage.
no, no, no.
Why didn't
You
affidavit?
file an
My lord.
affidavit, bring it on record, we'll do it.
My lord.
This we are returning to you, you also file an affidavit. You can do it by how many days?
Within 2-3 days, I can file it. No,
Within 2-3 days.
Yes.
So we take up next,
Next.
on Friday or Monday?
Next Friday.
Friday. And you, how much time will it take?
My
File an
lord,
affidavit?
will not take much time, my lord.
Friday or Monday, when do you fix it?
My lord, next week,
Monday?
Monday.
yes, my lord.
Okay,
Monday, no?
Uh,
Next Monday.
okay. All sides are represented. Mr. J. Pang, Leonard, standing counsel for the Home Department has produced an inquiry report pursuant to order dated 31/7/2024 from the inspector within bracket border, bracket was Borbeta, indicating that the proceedee Sap Khatun, the spelling is SAP. Sap Khatun and the present petitioner Sahemon, Shahemon Nessa, are both two identities of the same person. Full stop. Let the said fact be brought to the notice of the court by way of an affidavit, or on record by way of an affidavit. Full stop. Next person. The, Mr. A.R. Sigdal and counsel for the petitioner also undertakes to file an affidavit to bring on record that the Saab Khatun and Simon Nasa are same and one person. Accordingly, matters stands adjourned today to enable both sides to file affidavit. List on next Monday is 12.
My lord,
In
one
motion
thing,
form.
my lord, my friend can clarify, the LBO report name is Map Khatun. My lord.
No, you see, your challenge to maintainability, we are not questioning.
My lord,
So whether it is X or Y,
My-
it's not concerned, but the problem is now with the writ petition.
my lord,
In the writ petition, there, if there are two identities, we find it difficult to pass an
My-
order.
Upgraded item 42 for orders.
Need please, Your Lordship. This is a 389 application. On the ground that the person has suffered cardiac stroke. The Lordship comes to page 19, annexure 2. Lordship, this is a type copy of medical certificate of Morigaon outpatient record. The Lordship sees dated 18. Page 19, annexure 2.
Just a moment.
My Lordship. Date of registration 18/6/2024.
Just a moment.
My Lord.
Haji. Haji. কিন্তু অফিসের মাজতে এগুলো কাছে বাজাতে ঘুমাই গেছে একটু বেলেগ করে দেখো ঘুম না পাই কি হয়েছে অফিসের মাঝে দেখলে গায়ে গেছে এখানে age mention করা নেই। The discharge certificate of the Guwahati Medical College,
My lord,
where is the diagnosis?
dated first, 3rd of July 24.
Yes,
Yes, my lord. He also diagnosed with Alzheimer. The discharge certificate says. In fact, my lord, the brief clinical history of the discharge certificate, it will show that the deviation of his mouth, angle of mouth. Point number 3, deviation of angle of mouth from 11 days, which generally happens after a stroke. One side of the face slopes down. This is my only guy, 74 years old, not able to look after himself. Only
yes, Mr.
small
Das.
clarification, my lord, before
My lord,
this GMC certificate, it says he's 62 years of age. His 313 statement was recorded in 2012. On that day, he was 62 years. So GMC certificate, that age is wrong. I in fact have this Aadhaar card, if your lordship wants to verify.
That's okay.
now, my lordship may kindly see the order dated 16/7/24. By that order, my lord, my learned friend was directed to my lord, obtain instruction from the my lord, superintendent of GMCH, where the petitioner was treated, my lord, admitted and treated, my lord. Lord, I have received one report, but we received this report through WhatsApp message. But I could not type it out.
That's okay.
As per this report, my lord, he has improved. He was treated for Alzheimer and my lord, vascular
Cardiovascular.
cardiovascular accident. Now, clinical after my lord, giving treatment, my lord, he has improved. Last paragraph may be seen. After providing all necessary treatment, the patient clinically improved. Based on clinical examination and investigation, he was diagnosed with the cardiovascular accident. In fact,
Cardiovascular infarct, systemic hypertension with Alzheimer disease.
in fact, systemic hypertension with Alzheimer disease. So from report it appears that he has improved, my lord. Movie कौन सी है इसमें? Movie कौन सी है?
Alzheimer.
Who's there to look after him in his family?
My lord, he has his wife and two daughter-in-laws because the sons, they are also in jail with him.
Who will look after him?
He has his wife and two daughter-in-laws who's at Morigaon. Problem is, my lord, after this stroke, his face has distorted. He has to be fed by somebody. That's the biggest problem.
But the report from the jail does not indicate that.
Facial.
No, facial thing is a different
It might-
issue, but the fact that he has to be fed, he has to be looked after, all these are
Yeah,
not there.
I understand, my lord, but that is what my instruction is because
How can they give you an instructions?
lordship, we made a jail visit through and then it was he was brought to us because he has to be fed by his sons are feeding him in jail. Owing his age 74 years, this is my only ground, my lord. Just medical ground, nothing else. In fact, my lord, last year he was granted interim bail. He suffered a stroke then. If your lordship takes up the main appeal, there's an order. He was granted bail. Subsequently, he was treated for 2-3 weeks. Then he surrendered. This is the second incident that happened. In fact, if your lordship takes up this order, lordship takes up order dated 11/9/2023
In the IA,
in the criminal appeal, original appeal. 11/9/2023. My lord takes up the second paragraph. Learned counsel for the appellant has submitted that notwithstanding that ISO and so has been disposed of, but as per his instruction, the appellant number 1, who is age 72 years, is suffering from various ailments, including chronic lacunar infarct in right insular region, age-related diffuse cerebral and cerebral atrophy. All these are because of the stroke with small vessel ischemic changes. In hypodense area in right parietal lobe involving both gray and white matter as described, suggestive of acute infarct in right MCA. My lord,
he was directed to be,
regularly diagnosed. He was being diagnosed. That was being done. I will not deny, my lord. But subsequently, this again happened. In fact, my lord, in my petition, what I have annexure 2, that is at page 19. That is of 18/6/2024, when he was taken to Morigaon Hospital. He was feeling uncomfortable. Subsequently, on 20th, he was admitted because of this stroke.
what do you say, learned APP?
My lord. My lord, from the report, it appears that he has improved, my lord, and he has been discharged. And he was asked a review in 2 weeks.
When was the
Yes, sir.
report?
19/7.
19/7.
19/7,
24.
24.
Now, by now, whether review has been done or not, I do not know. Now, the case is otherwise ready for hearing. Paper book is ready. Or we can get it disposed of within a week, entire matter can be heard. Since he has already improved as per medical report, my lord.
There's only one query. Can you ask someone and tell us, in this case, the petitioner was in treatment under the medicine department.
Medicine as well as neurology.
Neurology.
Acha, both.
Yes.
Both.
MRI was done.
And psychiatry department also below.
All three
Consultation, at
departments.
consultation, yes.
From where do we find that?
In the report,
We
below.
have this report.
That report I have submitted,
That is why the Department of Medicine.
medicine.
No, my lord, it states that the patient also received necessary consultation and treatment from Department of Psychiatry and Neurology. Second paragraph, my lord, second paragraph, last line.
Yes. The patient was admitted in the male medicine ward under unit so and so, case of CVA. In her. Later on, psychiatric department. This treatment, appropriate treatment was started in the ward and necessary investigation, MRI, brain. The patient also received necessary consultation and treatment from Department of. The patient also received necessary consultation and treatment from Department of Psychiatry and Neurology.
You proceed for a review, and in the meanwhile, in the next week, we are keeping it for hearing. This review, they have asked for 2 weeks,
Maladies.
review in 2 weeks.
As you
You
request
have
for the
this
first
review
page.
done. In the meanwhile, next week, we'll fix it for hearing. From 3 to 14 is 17th. Sorry, today is 5th. No, from, sorry, 3rd.
Today's fifth.
3rd to 2 weeks is 17th. To get us a report by 21st. And in the meanwhile, we fix the matter for hearing.
21st of August,
No, we'll put it for hearing before that.
my lord.
Paper book is ready.
Paperwork is ready.
Any matter is fixed on 13th.
No, the report is from the reserve of the-
But Mr. D.K. Bhattacharya and counsel for the petitioner. The applicants. As well as Mr. D. Das, APP for the state. Next person. Guys, filing this interlocutory application. The applicant who is the appellant in the connected appeal has prayed for suspension of sentence under section 389 within bracket 2 CRPC on the ground that during the course of his incarnation in jail, the petitioner has suffered a stroke for which he was brought to the Guwahati Medical College and Hospital. Next paragraph. Pursuant to the order of the court, the learned APP has produced an advice note from the Department of Medicine, Guwahati Medical College and Hospital. From the said document dated 19/7/2024, the Registrar of Medicine, Guwahati Medical College and Hospital has enclosed a note which discloses that the applicant had complained of general weakness for 12 days and deviation of mouth for 11 days. And that he was a known case of Alzheimer's disease. And had also suffered cerebro, cerebrovascular cerebrovascular impact, IMPACT. No, this is not in fact, in fact, INFARCT. Incorrect. Where is the correct spelling of this word?
My lord, INFARCT.
City.
City.
In fact, and the next word is
Possession. My lord,
in
is
fact,
ISCHEMIC.
ischemic hypertension.
My lord.
It's so bad. Okay, systemic hypertension, SYSTEMIC. Systemic hypertension. Stop. As per the said certificate, the patient has received necessary consultation and treatment from the Department of Psychiatry and Neurology. And that after receiving all necessary treatment, the patient is clinically improved. Next, the learned counsel for the petitioner has submitted that the that as per instructions received by him, it will be applicant. The applicant is unable to take care of himself and he is required to be fed by attendants. And then presently the applicant is being attended by his two sons who are also suffering sentence along with the petitioner. Next para. As from the medical opinion, it appears that the applicant is required to be produced before the produced for review before the medicine and neurology department of Guwahati Medical College and Hospital, comma. The court is inclined to await the outcome of the review medical checkup of the applicant, namely
Rajeshwar Bordle.
Brajeshwar, Brajeswar, Bordoloi. Accordingly, the superintendent of
District Jail, Morigaon.
District Jail, Morigaon, shall take steps as may be required for having the medical review checkup of the petitioner be conducted in the Psychiatry and Neurology Department of Guwahati Medical College and Hospital within 2 weeks, as per medical advice. Next para. The learned APP shall transmit the order of the downloaded copy of the order passed today to the superintendent of District Jail, Morigaon, to enable the said authority to do needful. Next para. Considering the nature of illness suffered by the applicant, comma, separate order is being passed in the connected appeal for out of turn hearing. Next para, list this interlocutory application on 19/8/2024. Awaiting receipt of medical report from the authorities. In the connected appeal, you write, heard so and so, in view of opinion expressed in the reasons expressed in the order passed today in the connected IA criminal 603 of 2024. The court is inclined to direct that the matter be heard after turn. Next para. List for hearing. List for out of turn hearing of the matter on 13/8/2024. Okay, the medical documents, medical reports released is made a part of the file.
What are a copy of this order maybe?
You'll get it, either you take it from him or it can be downloaded. I have allowed you to download it copy.
Mark. Okay.
We'll try to see that it comes, it is uploaded today. We'll have to rise because there's a single bench of both of us. I know, Matthew. Okay, so this is the only matter. You please tell your senior that this is the only matter.
My lord, they were arrested on 19/5/2022, my lord. The arrest memo is at page number 20, lordship. 19/5/22. Subsequently, my lord, the investigation was complete. Lordship, page number 49 reflects that in total there are 14 number of witnesses. And to the best of my instructions, my lord, PW1 has been examined, my lord. Continuing. Yes, my lord, 13 are left. Charges were framed on 18th of May 2023, my lord. 1 year and 2 months back. 18/5/23, my lord. That is at page number 51, lordship. That is page number 51, my lord. That is the order of charge. And page 49, which is the penultimate page of the final complaint or the charge sheet, that reflects the total number of witnesses, my lord. LCR is before your lordship.
Lordship में LCR is there. Lordship order dated 19/7/24, which reflects that it took about 4 days to complete the cross-examination of PW1. And next date is fixed on 2nd of September, 3rd of September, and 4th of September for further examination of other witnesses on 3 consecutive dates. Lordship,
Lordship, the very first bail petition of these applicants was disposed of by your lordship. That was at a very early stage of time, my lord. Charges were also not framed, my lord. My lord, that is at page number 69, lordship. Lordship's order. Lordship had discussed with regard to the merits in proper perspective, my lord. Paragraph 9 onwards are the findings of lordships. At page number 72, my lord. Lordship's rejection order, my lord. My lord.
but you know, that's clear. Forget the one. Lordship. Lordship, contaminant ceased from their position. Contaminant ceased from their position. Lordship. Lordship may come to page 27 of the bill application. 27, Lordship, paragraph 4. Part of the complaint, paragraph 4, I am reading, Lordship. That sir, officer of AS unit of custom division with assistance of the other officers of the custom division Karimganj, headed by deputy commissioner custom division Karimganj, intercepted 14-wheeler truck bearing number so and so at about 21:30 hours on 18/5/2022 at toll gate Barkhasal Karimganj. So while the truck was coming from Agartala, on preliminary visual examination, the truck appeared fully loaded and covered with tarpaulin. On query, both the driver, Sri Salil Sharma, and the handyman, Sri Akshay Kumar, of the truck denied carrying any contraband goods. At the time, passers-by were requested by officers to remain present there, an independent witness for completing the search formality. At home, one Sri Mosak Ahmad, number 2, Tajuddin, agreed to become the independent witness. Yet it was not feasible to undergo thorough checking of the truck on the national highway. The truck bearing registration number so and so. The driver and the handyman were brought to the custom office division so and so. The two independent witnesses also came along with the officers of the anti-smuggling unit of custom division at Karimganj. After reaching the office, some hired laborers were called. In presence of the driver, the handyman of the subject vehicle, the two independent witnesses, the unloading containing weighing of goods was started, which resulted in recovery of 35 packets of containing dried cannabis in compressed form in assorted size and worked outwardly with newspapers and brown colored cello tape, which was concealed among the packets of natural rubber, so and so. Thereafter, the recovered 35 packets of cannabis were weighted on an electronic weight scale and recovered one by one in weighing sheet, where total weight of the cannabis measured 533.635 grams and 530.1 kgs. Net, the recovered cannabis value to 79 lakhs odd. So this way, this contaminant were recovered from the truck, where the both petitioner, where one is a driver and another is a handyman also. So this is a latest judgment passed by the Honorable Supreme Court. Paragraph 5, 6, 7, and 8, Lordship. State of Meghalaya versus and this is a judgment passed by Lordship in similar bail applications, where all the judgments passed by the Honorable Supreme Court have been taken into consideration. Lordship? No, Lordship. They have not. One judgment has been set aside where Lordship has rejected the bail. One judgment was not set aside, but Supreme Court said that co-accused has been granted bail, so they should also be granted bail. Otherwise, nothing intervened has been made by the Lordship. And this is the latest judgment of 16/7/2024. Lordship. Lordship. This is two-line order, Lordship. I'll supply Lordship tomorrow. Lordship. Lordship.
Lordship permits, my lord. My lord, I have a compilation of about 8 to 9 Supreme Court judgments, my lord, with regard to period of incarceration, where Lordship the bar of section 37, as in my case, is applicable, my lord. The 37 is a huge embargo, Lordship, with Lordship's permission. But I And Lordships, apart from the 8 apex court judgment, there are 3 judgments of Lordship coordinate bench of this honorable court, Lordship, which I am not bringing, Lordship, those are not binding on your Lordships. However, in those judgments, Lordship, with regard to the period of incarceration and when Article 21 is Lordship read in the light of section 37 of the NDPS Act, then Lordship, what amounts to long incarceration, that has been discussed, Lordship. Page 65 is one such judgment, Lordship. I had only appeared, and there are similar judgments. These are not, Lordship, again, I'm stating, not binding, Lordship, just for Lordship assisting the court, Lordship, because apex court judgments have been discussed at length. And Lordship, that 37, section 37 of the NDPS Act should not be read alone, but my lord, should be read in the light of Article 21. And Lordship, when in circumstances where it appears that trial might take, Lordship, very prolonged time, then Lordship, whether 31 would override the right to liberty of the accused persons, my lord. Similar, Lordship, all are commercial quantities, Lordship. In fact, in certain cases, quantities more than the alleged, Lordship, present petitioners. And Lordship, period of incarceration, that Lordship, where in the first judgment that Shariful Islam and Sarif, after this Lordship, this started to flow, that long incarceration, apex court is seen that when Article 21 and 37 is read in light, then the apex court is of the opinion that about 1 year and 6 months passes and trial does not progresses, then Lordship, that is considered to be a long incarceration. And it is seen that in circumstances like this, my lord, that Article 21 overrides, my lord, section 37 with regard to, my lord, the embargo being there as regards to bail. My lord, with regard to the merits of the case, because nothing has progressed, when Lordship had rejected earlier in the year 23, at that time, whatever material was available, today also it is the same, except for, my lord, I believe PW1, who happens to be a Caesar witness, my lord. My lord, with regard to merits, one small thing I would like to point out, my lord, may come to page number 22. This possibly, Lordship, I cannot claim as a matter of right in a bail application, but my lord, this could be fatal for the prosecution during the trial, at the end of which, my lord, I might be set at liberty, my lord. Page 22, which is the inventory of goods seized, my lord. My lord, at column number 3, place and date of seizure, detention. Initially detected the 14-wheeler Tata truck bearing registration number JK02C. My lord. My lord, bail application, yes, my lord. My lord, I apologize, my lord.
22
referring
bail
to the
application
complaint.
is inventory of goods seized.
Inventory
Yes.
of goods seized, my lord.
Yes.
My lord, place and date of seizure / detention. Initially detected 14-wheeler truck bearing number this and this at Tollgate, Karimganj district, this and this, on 18/5/22 at 21:30 hours. 18/5/22 at 9:30, and formally seized at the Office of Customs on 19/5/22 at 600 hours in the morning. So, Lordship, the seizure or inventory of goods, my lord, as per as requisite by the NDPS Act, my lord, which is very strict, as because the punishment also is very strict. Lordship, this adherence is not there, and Lordship, there is no document to the effect that where the goods were from 18/5 at 9:30 PM till, Lordship, the next day when the seizure was made. However, Lordship, to a certain extent, they have tried to explain that it's a big truck, and with regard to it, that to carry out the entire process, it would not have been possible at the toll gate, and as such, they took the vehicle to the customs office, which is explained, my lord, in the final complaint, starting at page number 25. But another thing, Lordship, which is of more importance, is their own document, my lord, in the final complaint at page number 34 of the bail application, at paragraph number 16. page number 34, paragraph number 16. My lord, that sir, the seized articles and the relevant documents were deposited in the NDPS Central Godam Disposal Unit of Customs Division, Karimganj, file number this on 25/22. So lordship, chain of custody in cases of NDPS, especially commercial quantity, cannot be lordship silent or broken even for a single moment. Lordship, any such lack or lacuna in the chain of continuity of custody, my lord, the advantage goes to the accused. So tomorrow, my lord, after at the end of lordship years and years of trial, if these conditions become, my lord, fatal for the prosecution case and the witnesses are broken, my lord, then this chain motion they've already admitted. This now cannot be made again, my lord. 18th seizure was made and 20th, my lord, it was deposited in the godown. 19th morning, official seizure was made. So even from 19th morning from 6 a.m. till, my lord, 25, till the next day, my lord, the chain of custody, my lord, remains incomplete. And if your lordship goes through the lordship LCR, entire documents would be available. I am stating from, my lord, the page number 50, which is the list of annexures or documents relied on. Lordship, there is no document which appears which shows the chain of custody from 19th till 20th, my lord. 18th night at 9 p.m. till 19th morning 6 a.m. Lordship, there is no document. However, lordship, there is ocular evidence that they carried it, labors were unloading, and that process was going on. But my lord, from 19th till 20th, lordship, the entire 19th till 20th, lordship, there is completely silent with regard to the chain of custody. This, my lord, possibly I cannot claim as a matter of absolute right in a bail application. However, my lord, these would come to my aid in the advantage during trial, my lord. And my lord, tomorrow at the end of the day, if, my lord, the accused are not proved guilty, already 810 days, my lord. And with regard to this, my lord, no other accused, whoever were the consignor, consignee, lordship, people have admitted. There are admission statements, lordship, which formed a part of the prosecution documents at page number 36. And people under whose custody the loading was done. And it's not that the ganja was visible to the driver's eyes. My learned senior friend has himself read that the ganja were found in concealed condition. And the loaders, my lord, the logistic agency under whose supervision it was loaded, lordship, they are not accused persons, my lord. No consignor, no consignee. There is no material to the effect that we have stopped somewhere and loaded goods elsewhere, my lord. My lord may go through paragraph 23, 24, and 25 of the final complaint, my lord. NCB's final complaint, that is page number 36 and 37, lordship. Page number 36 and 37, lordship. It shows that, lordship, truck was owned by one Jammu Tripura Road Lines. This was engaged by one DARCL logistics company. This DARCL logistics company loaded the rubber provided by one Apex rubber company, paragraph 24. And the gentleman who, my lord, loaded this, he himself admitted, once he Subir Sinha, he has said that the loading was done under his supervision completely. And then directly, lordship, this was caught. There is no material to the effect that elsewhere we have stopped and with connivance with someone we have loaded. Even though lordship 25 and 29 are there in the charges. All this, lordship, yes, lordship, I would agitate
That
during
is something which no one can prove.
Yes, my
It
lord.
was found in your vehicle.
Yes, my lord. Yes, my lord.
So where you have loaded, where you have not.
That
is
lordship,
something
yes,
is a matter
lordship,
of
that
trial.
this defense will be subject matter of trial. So, lordship, my most humble prayer before your lordship is on the lordship point of prolonged incarceration, my lord, 810 days. And when, my lord, the apex court has observed in certain occasions, as well as our high court, lordship, that when the time period of about 1.5 years has also passed, lordship, only on the point of prolonged incarceration, without speaking on the merits of the case, my lord, as to where the trial might lead, my lord, the accused persons have been, my lord, released from custody. And the judgments I have relied upon, my lord, are not of accused persons who were roped in later on or from whose possession it was not found. So I have not relied on such accused persons because that is, lordship, weaker. But I cannot deny the fact that it was found in the truck and, lordship, we were in the truck. Conscious possession is a matter of trial. So the 8 apex court judgments, my lord, are all of commercial quantities, my lord. And my lord, the period of incarceration, apart from one matter, is seen to be, my lord, much lesser than in case of mine, my lord. 1 year, 6 months, 1 year, 7 months. The apex court does not go into the merits, but only on the period of incarceration, where, my lord, the Article 21 outweighs Section 37 of the NDPS Act, my lord. That is judgment, and our High Court, my lord, only one judgment, and the lordship may rely on the last one at page 65, only for the lordship assistance of compilation of the judgments, my lord. My lord, any strict conditions may be imposed, my lord, 2.5 years, my lord. Lowest strata of the society, my lord, driver, handy, my lordship may kindly consider, my lord, on the light of the laws placed and the facts, my lord.
Let me go through it. I think the orders will be made online tomorrow or day after tomorrow, because
My
See, with regard to order submitted by my learned friend, probably Mohammed Muslim, beside Mohammed Muslim, all are the simple orders, Lordship. Nothing has been considered. And Lordship occasion to deal with all the judgment in Jitul Ali's judgment, Lordship. But we
still I
cannot
have
say
to go
that,
through the trial
Yes.
court records. It takes
Lots.
some time.
lots.
1 minute. Deeply obliged, my lord.
In all probability, it will be released day after tomorrow.
Lots.
Actually.